Hello, good afternoon, everyone. Am I
Good afternoon.
audible?
Yes, am I audible? Yeah, good way.
Yeah,
Yeah,
yes.
good way.
Okay. Nandini, Professor Chhokar is not joined.
No, sir, he hasn't. I'll check with him. Just give me a few
Yeah.
minutes.
Okay. All right. So I think without much ado, we will start. I'll welcome all the speakers and the people who are viewing this webinar. Hearty welcome from ADR. And we have a distinguished panel today, which is going to be speaking on this issue. Professor Jagdeep Chhokar, Mr. Gautam Bhatia, Mr. Nitin Sethi, and Mr. Vihar Dubey. Sorry. So, before we jump into the discussion per se, I would just lay down a few ground rules for the speakers to kindly adhere to. The modalities of the conduct will be that we will give each speaker about 10, 12, 14 minutes or so. And the order of speaking will be first Nitin, second Gautam, third Mr. Vihar, and lastly Professor Chhokar. And we had emailed some pointers for each speaker. If you have the time to go through them, it's okay. Otherwise, you can speak whatever you have prepared, and I'll try to get back to those pointers during the discussion or during the question answer session. So in the end, when everybody is finished, all the speakers have finished their talk, then we'll have a question answer session. And as had been mentioned earlier, that people will post their questions on the chat box, and we will be displaying them as a ticker tape at the bottom of the screen. And we will take those questions one by one, and we'll see how the time goes. Maybe 15, 20 minutes we'll devote to that. Before I call upon the first speaker to speak, there may be some viewers who may not be very familiar with what this animal called electoral bonds is. So we will just go over a couple of slides which we have made for such people. Nandini, I'll request you to just go over the slide once by one, please.
Sir, Anas will be handling the PPT. Anas?
Okay. Yeah, so this is what the Electoral Bond Scheme is. That was introduced in January 2018 by the then Finance Minister. And it is like a promissory note, basically, the electoral bond, which can be bought by any Indian or anybody operated in India from select branches of the State Bank of India. The citizen can then donate the same amount to any eligible political party of his or her choice. The bonds are encashed by eligible political parties. Another point here is that, firstly, they are all these donations via electoral bonds are exempt from income tax. That is, the political parties don't have to pay any income tax. And secondly, the bonds have a lifespan, I think, of about 15 days or so. So if they are not encashed in that duration, then they go back to the government in that fund. Okay, next slide, please. This gives the details of all the 15 phases in which the electoral bonds sale has been opened. So the figure in black gives the amount of electoral bonds sold in rupees in crores. And below that, in a little faded thing, is the amount of electoral bonds which have been redeemed. You will see that by and large they have all been redeemed, barring a small amount. And the thing which I want to point out here is that you will notice that just before the general elections, there is a spike. If you see March 2019, 1,365 crores. April 2019, 2,256 crores. So a total of 12,924 electoral bonds worth about rupees 6,534 crores have been sold till now. It is quite a huge amount. Okay, next please. So this gives the details of city-wise purchase of electoral bonds. We just pick up the major cities. If you will see, the maximum sales are in Mumbai, followed by Kolkata, then New Delhi, and lastly Hyderabad. And denomination wise, if you see, why I made this slide is that I wanted to highlight the fact that, and you see the denominations of the electoral bonds has been given on this slide. So it is, 1 lakh, 10 lakh, 1 crore, and so on. You will find that most of the sales have been of the higher denomination electoral bonds. Okay, next slide, please. This is the amount which each party has received via donations from electoral bonds. Since in the public domain, that is with the Election Commission of India, the details which have been shared by the political parties via their donation reports and contribution reports pertain only to 3 financial years, starting from 17, 18, 18, 19, and 1920. You will notice that for financial year 1920, most of the political parties have still not declared, or they have not submitted the detail, or they have not got it, or whatever. So 2018-19, the details are there. Okay, next slide. Okay, next. So this is about the ADR's petition, which we filed against the Finance Act on 3rd October 17. Basically, we challenged the Finance Act, which was enacted as a money bill. This is the one which introduced the Electoral Bond Scheme for the purpose of funding. Next, please. So on 5th March 2019, we filed an application for the stay against the sale purchase of electoral bonds for the 2019 Lok Sabha elections. And finally, on 12th April, the Supreme Court heard this and they directed all political parties to submit details of the donations received via electoral bonds to the Election Commission in a sealed cover on or before 30th May 2019. Next, please. On 29th November, ADR and Common Cause together filed another application to bring on record certain vital documents which had surfaced to the RTI applications filed by various activists and citizens, including ADR. Next, please. On 26th October 2020, ADR and Common Cause filed another application for an urgent listing of the petition before the Supreme Court of India. Next, please. So as early as a couple of days back, this was listed on 22nd February, but was not heard. And now it's the website says likely to be listed on 26th February 2021. One point which I want to highlight here is that so many times on the Supreme Court website, these petitions have come up as likely to be listed number of times. I would say more than 10, 12 times in the past 1 year or so. But somehow it is not being heard. Probably other pressing matters are there with the Supreme Court. Okay, next please. Thank you. So a point which I wanted to highlight here is that the electoral bond scheme, basically most of the various agencies, like Reserve Bank of India, the Election Commission of India, even the law ministries, and of course, a lot of MPs in the Rajya Sabha had not only shown their apprehension, but had also given repeated warnings to the government against introduction of this electoral bond scheme, stating that this has the potential to increase black money circulation, money laundering, cross-border counterfeiting, and forgery. And these institutions had strongly opposed the mechanism of electoral bonds and made serious reservations against it and termed it as a bad precedent. However, the government has always touted the electoral bond scheme as KYC compliant and totally transparent, whereas we, the civil society, and a lot of other people feel that it is exactly opposite. Actually, it is opaque, and by not disclosing the details of who the donor is, how can you call it transparent? So, with that as the backdrop, I think I'll now invite the speakers. So, like I said, first I'll request Nitin uh, to start the discussion. Brief introduction. Nitin is a well-known journalist, as we are all aware, and he has won prestigious Investigation Journalism Award, which is given by the Asian College of Journalism, for the series of stories that he had published on electoral bonds. He has previously worked with Down to Earth India, Times of India, Business Standard, and The Scroll. He is the member of Reporters Collective and also the media lead at the National Foundation for India and partner at the Land Conflict Watch. So over to Nitin.
Hi, am I audible?
Yes, we can hear you.
Hi, good afternoon, everyone. Um, Let me start by saying how we as journalists got into the story. ADR and others had been pursuing it on a fundamental and principle basis, looking at the consequences of having something like the electoral bonds. We as journalists at the Reporters Collective reached it because Commodore Lokesh Batra had spent, I think, more than a year quietly digging out through RTI documents from the government of India on what the electoral bonds were, how and why they had been created, or what was the intention of the government behind it, and how they had functioned. Later, Ms. Anjali Bharadwaj also was able to, through RTI, get the same documents, and we use this as evidence to look at and answer these 3-4 questions again. What was the intent of the government beyond what it had claimed in public domain? Two, did it fundamentally alter or potentially hold the risk of altering how politics in India would run, for better or for good or for worse? And 3, had the government, even if one considered that they had done something which a large section of society thought was not a good idea, had they even followed the rules that they had set for themselves in pursuing this electoral bond scheme? Our conclusion at the end of what was a 10-part series of documented evidence presented as stories in multiple languages and in podcasts, etc., was that the entire scheme, its functioning, and its creation was riddled with impropriety, with illegality. It lacked any sense of ethics in how it had been applied and how it was implemented. It was done in bad faith and potentially was in violation of our constitution values and provisions as well. Beyond that, I think what was clear as evidence produced, thanks to, again, Commodore Lokesh Batra, that the scheme itself held a great risk of destabilizing an already not so healthy way of political funding in India. It legalized what was otherwise, at least on the paper, an illegal practice of providing unquantified amounts and untaxed amounts and unknown amounts to political parties through obscure routes. In some sense, if we look back, it had legitimized crony capitalism and given it a legal cover at a scale which was at least morally not acceptable in India for a while, even though it was in practice, I would say otherwise. Now, to get down to the facts, and I'll try and summarize them quickly because I think a lot of us might remember them anyway, is the government brought these electoral bonds claiming it would bring transparency. Evidence came out to show that that transparency did not exist even during the formation of the bonds, as previously was told. The government breached the trust as well as defended itself against very strong views of institutions like the RBI and the Election Commission, and yet went ahead with this. The government pretended to be consulting the opposition political parties and its allies, and yet bypassed them in formulating it. In doing so, it created legitimized loopholes even in the scheme itself of how it would remain opaque about where the money was coming from, what was the nature of the money, and who it would go to. We do see from evidence which is available, we do know that the party in power, BJP, at the moment in the center, has received a larger part of these funds. We found that even though the rules were created against the wishes and advice of several constitutional authorities, that those rules itself were breached very quickly by the union government itself in implementing it. Say, the funds were not to be collected around the times of state elections. On the instructions of the Prime Minister's office, the rules were breached and funds were collected through this process even during that time. Windows of electoral bonds were open at times when they were not allowed, again with the instructions of the Prime Minister's office. And we found that while some institutions pretended to at least put up a notional argument against it, at the end, each one of them, in the face of a very determined government, backed off and did not perform their full constitutional and legal duties. They did not take the actions that they were legally mandated and responsible for to ensure something like this does not see the light of the day. And I would point to, while RBI does write a letter at some point saying that this is a bad idea, if you look at the role that the RBI or the role that the Election Commission had to play, they did stop short of what was their fair duty to be done to protect democratic processes in India. The fact, as again mentioned, that the Supreme Court itself in the last couple of years has been found itself unable to hear this matter does raise serious questions about how the Supreme Court prioritizes what are matters of greater importance, priority, etc. We do not know reasons why the Supreme Court has been unable to hear this matter, as the previous speaker said. Perhaps it has other priorities and hard-pressing cases to address. I would argue that may not be the case if you look at on the face of what Supreme Court has been hearing on a daily basis. That said, there are fundamental issues that a process like this brings as a challenge to Indian electoral democracy. It permits unaccounted for an unlimited amount of money to flow into political parties, not only from India, but also from outside, which to my mind in a democracy, if a political party and the executive in power should only be answerable to the citizens who vote, it creates the opportunity for the executive to be answerable to its funders more than it is to its voters. And that is clearly a very unsteady and shaky bedrock on which to build an electoral democracy. It's the fundamental definition of what crony capitalism is, where large corporates who otherwise should have, and under the constitutional provisions should have no say in the nature of our executive governance, actually get a backroom entry into decision making, because like any good businessman and any other good business person, electoral funding would be seen by a good corporate as an investment into future where policies are driven in favor of their businesses. All smart and any business person would look at it as an investment into their future returns. And therefore, they would expect this return from those they've funded, and if they come into power, to create policy frameworks, laws that promote their business for good or for worse. The fact that this happened earlier does not condone the fact that it now will happen under a legal cover. We do know that black money or unaccounted money or untaxed money has played a large role in India's electoral politics even before this. but at least on the face of it and notionally, it was illegal. There were attempts being made to further reform it, move into a direction where every penny would be accounted for when it goes into the hands of politicians and political parties that stand for elections. This, in some sense, is a great regression. It undoes years of attempts to move ahead, years of attempts by organizations like ADR to push for reforms in this arena. There's a large question that rises, I think, out of this for journalists like us who very often cover and or uncover stories of corruption, of malfeasance, of crony capitalism. I see all those stories as the symptoms of bad electoral funding to start with. Where we've reached today, in some sense, is a place where bad and really ugly electoral funding processes now have a legal cover, which the Supreme Court at the moment is not being able to hear and talk about. A reform in this could fundamentally alter the nature of our democracy. It is not a matter of whether it's 6,000 crores at the moment and it could be 20,000 crores in 2 years of money collected by politics. It would just fundamentally alter who is our executive answerable to. And we should always have the first principle that the executive is answerable to none others but the voting citizens of the nation. This scheme fundamentally alters that relation in favor of a class of powerful people who have great vested interest in influencing policy to increase their profit making zones. I would end with a couple of thoughts on where we see the challenges arising in the next few months on this. As a consequence of our bringing out these stories and reportage and the RTIs that Commodore Batra and Anjali Bhardwaj filed, and the public furor that was created with ADR persisting with its cases, with publicly speaking about it, raising it at different platforms, is that the government has gone even more quieter in responses to RTI pertaining to electoral bonds. And this is true for the SBI, it is true for the finance ministry, it is true for the prime minister's office, it's true for all segments of the government, that instead of showing more transparency in what they claimed was a very transparent scheme, they have gone completely cold, silent as a response to the public efforts of so many well-thinking and well-meaning people. I think that itself, to us as journalists, smells of a dead rat. It creates great doubt about what is being done. As journalists, what we can do and we intend to do in the next month or so is to produce yet more evidence of how this scheme has really worked. Despite the attempts by the government to prevent information from coming out, we've been at our work and we will produce more. But we must, I think, thank a lot of individuals and right-minded people across the spectrum who've kept the voice up on this issue, because this is not a short-term thing. It will, in the long term, alter the nature of how our politics is done. It wasn't anyway great, but we were trying to push it towards betterment. The question I leave at the end is, if you look at the attempt, the concerted attempt that the government made to get this scheme through in the fashion that it wanted, to me and to anyone who thinks of it analytically, regardless of which party is in power, would know that the intent and the kind of money the scheme would bring to the political class was very clear in the minds of those who wanted this scheme. The second line of question one must have is, why was this money required in this fashion? It's not as if black money is not already available in the market for electoral politics. If this black money channeled through banks, legalized by a law, available in the bank accounts, away from the minds and eyes of average citizen, was to be made available in thousands of crores, clearly the party in power, BJP in this case, knew why it wanted that money. I think the next layer of questions that of which we must peel and find answers is, to what end is this particular kind of black money? And I keep using this word very categorically, because just because it comes through a bank account does not mean it's not unaccounted, untaxed money, which is why this government itself has gone after these companies and saying these are shell companies. Where is this money being deployed? Was there a specific emerging use in the Indian electoral politics economy of this specific kind of money? And I think therein lies our answers of why it's not a large sum if you look at in proportion to what we always hear about the amount of money that is spent in an election in India. It's right now about 6,000 crores. I would presume this is not even a third of what overall gets spent. Yet there was a clear desire for this kind of money coming in this particular format. I think for all of us, beyond pursuing it in the courts, which ADR is doing assiduously and RTI activists are filing their application, is to think through and understand of what use would this money be put. Is there a specific use where other kind of money generated through other black routes could not be put? And that will give us some understanding of how our political parties see the nature of electoral politics and its funding change in the next few years as the nature of our economy changes itself, as the nature of reaching out to citizens changes, as the nature of parties' own way of reach and propaganda as well as advertisements change over time. I'll end with this and later respond to all colleagues, panelists, and viewers. Thank you for the opportunity.
Is General Verma online?
I'm supposed to go next, so I can start.
Yeah, I think this connection is weak, so Gautam.
Why don't you do that, please?
Yeah, no. So thanks. So I mean, first, sorry, my internet's been very flaky all day, so I'm off camera to try and so it preserves.
I can't see your picture nor your name. Can you please introduce yourself?
Yeah. My name is Gautam Bhatia. I'm a lawyer.
Okay. That's enough. Welcome.
Yeah, my camera is off because my internet's been flaky, so I'm trying to preserve my video.
That's fine.
Yeah. So my subject is institutional complicity in this case of electoral bonds, and being a lawyer, my primary focus is on the courts, and in this case, the relevant institution is, of course, the Supreme Court, where the case was filed in 2018, and which is now approaching 3 years without a judgment. So the Supreme Court's, I think, actions in this case reflect something that I call judicial evasion, which basically means that the Supreme Court or whatever court that might be seized of a matter refrains from hearing a case, but its very decision not to hear a case favors the party that is in a stronger position or favors the party that benefits from the status quo. And the longer the time goes that a court refuses to decide a case, the more benefit one party receives, and that ultimately amounts to effectively the court deciding a case by not deciding it. There are some prominent examples of judicial evasion in recent times. Perhaps the most prominent is the Aadhaar case. The Aadhaar program began in 2012, and it was 2018 before the case was actually finally heard, which is 6 years. And during that time, Aadhaar had effectively become a fait accompli. And in fact, one of the arguments made by the union government in court was that we have now registered 1 billion people, so you can't stop this program. Of course, the reason why was the court hadn't heard it yet. Similarly, in the Supreme Court, the constitutional dispute between the government of Delhi and the Union of India over the powers enjoyed by the legislature and the executive of Delhi was kept pending for many years. And when the decision finally came, it was unclear, and in fact, the two-judge bench that decided the case was split on a range of issues, and final judgment has still not come. And in fact, there's been one entire term of the Delhi government has passed. Elections were held, and you have a second term of the Aam Aadmi Party, and the scope of its powers are still under dispute in the Supreme Court. And of course, that inaction benefits the central government. So judicial evasion basically is that by not deciding or not hearing a case, the court effectively decides in favor of the stronger party and the party that benefits from the status quo. And the electoral bonds case, in my view, is a classic example of judicial evasion. As we've seen, the case was originally filed in 2018, if I remember correctly, in fact, in February or March 2018. So it's actually been 3 years. The question of when a case is to be heard, and in the Supreme Court, is primarily in the hands of the Chief Justice, who is euphemistically called the master of the roster. And when the case was first filed, Chief Justice Deepak Mishra was Chief Justice, and it wasn't heard during his tenure. He retired, and then Chief Justice Gogoi became chief, and it still was unheard. And when 2019 elections came by, at which point, if there was the first substantive hearing of this case, and that's something that's been referred to in the presentation before we began. And the interim order that we saw, that was referred to in this presentation, actually is in my view, a classic example of judicial evasion. So as Mr. Nitin Sethi rightly said, the electoral bonds case involves the Electoral Bond Scheme, which is a method of political funding that is defined by donor anonymity and the elimination of caps on corporate funding. So what happened in May 2019, when the case was finally heard, or partially heard, was that the Supreme Court heard it for 3 days, and then passed an interim order where it refused to stay the scheme. So the Electoral Bond Scheme would carry on, and directed that the details of funding through electoral bonds be made available by political parties to the Election Commission in a sealed cover by 30th of May, which is after the end of the 2019 general election. So the election would finish, and after that, in a sealed cover, the political parties would provide details of their funding. Classic example of shutting the stable door after the horse has bolted. And of course, also to point out that it's rather ironic that the whole challenge is premised on the voters' right to know, and the voters' right to know the sources of political party funding in a democracy. And the case is premised on that. The direction was that in a sealed cover, these details be turned over to the Election Commission pending final judgment of the case. I think one particularly, one thing I want to focus on is paragraph 11 of that interim order, where the court says, and I'm quoting the paragraph, that all that we would like to state for the present is that the rival contentions give rise to weighty issues which have tremendous bearing on the sanctity of the electoral process in the country. Such weighty issues would require an in-depth hearing which cannot be concluded, and the issues answered within the limited time that is available before the process of funding through the electoral bonds comes to a closure, as per the schedule noted earlier. So the case was at this time being heard while one of those cycles was open in view of the general election. And this is what the court said. Now, this is a deeply disingenuous thing for the court to say, because what the court didn't mention in this May 2019 order is that the constitutional challenge that it was hearing had been filed in early 2018, more than a year before this particular hearing. So it wasn't as if the petitioners had sat on their hands and waited for the general election to begin and then rushed to the court. The scheme was challenged almost immediately after it was enacted into law. The Supreme Court back then issued notice, so it admitted the case, and then nothing happened. In the meantime, electoral bonds were issued on multiple occasions by the SBI for multiple state elections. A significant amount of political funding at the time, more than 100 crores, was secured through the mechanism. And the overwhelming bulk of it went to the ruling party, because it's important to note that one of the issues with electoral bonds is that it's asymmetrically anonymous. So the ruling party can know, government can know through SBI who is donating to whom, but nobody else can know. And the obvious consequence of that is that, and as we have seen, that the donations will skew massively in favor of the ruling party, in this case the BJP. But whoever would be the ruling party at any given time, the skew would be in that party's favor. So if the issues at stake were as weighty as the court admitted they were in May 2019, then surely they were as weighty in 2018 as well. And the court knew this. At the time the Electoral Bond Scheme was enacted into law, there were strong protests. And later in 2018, former Chief Election Commissioner publicly criticized them. Everyone knew that the national election would be held in spring 2019. And the court knew as well that an in-depth hearing would be required to adjudicate upon the issue. So then to turn around and act as if these are all fresh developments that ambush the court or took it unawares is clearly very, very disingenuous. The responsibility for why this hearing ended up taking place in the middle of the 2019 election rested squarely upon the shoulders of the court, especially when the schedule for issuing electoral bonds was pretty much publicly known. And then in paragraph 12 of this same interim order, the court noted that the court therefore has to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but that the same ensures adequate safeguards against the competing claims of the parties, which are yet to be adjudicated. So it effectively said they are balancing the competing claims in this interim order. But this method of ensuring a balance was a very strange one, because it effectively simply let the scheme continue. Simply making an order that the details of the donations be made available to the Election Commission in a sealed cover accomplishes nothing at all in terms of what the petitions were about. It would make sense if there was a suspicion of illegality in the process, that then you would set aside the election results if there was something illegal. But as Mr. Sethi pointed out, the entire constitutional challenge is based on the argument that the Electoral Bond Scheme legalizes wholesale political corruption by allowing for limitless, secret, corporate donations to political parties. So how was it that the interim order of May 2019 balanced the interests of the parties, especially given that massive chunk of funding to electoral bonds had already taken place over the previous year because of the court's own failure to hear the case? So if you look at the hearing of the order of May 2019, it's a classic example of judicial evasion, where the court, in a certain sense, began to hear the case and immediately stopped and passed an order that it claimed was balancing the rights of the parties, but actually was doing nothing of the sort and favoring the continuance of the scheme. And then after that, the case has not come up again. And again, it's also important to remember that the Supreme Court frequently grants stays on the first day of hearing, after a couple of days of hearing. This is a very frequent occurrence in the court, so it would not have taken much to realize that that staying the Electoral Bond Scheme pending a decision on its validity is actually the correct balance, because it would simply take the situation back to the pre-electoral bond status quo of political funding, and wouldn't irreparably damage any party's interests. But the court did not do that. And after that, it has not been heard again. When the Chief Justice retired, he was interviewed, and he said he didn't remember the case at all. And then Chief Justice Bobde became chief, and I think there was one brief hearing on one day in the beginning of 2020, and then again it's been in cold storage. So I think that this is a clear example of institutional complicity in the sense that that the Supreme Court, that whose task it is, among other things, but whose primary task is to be a referee of democracy, which is to ensure that the rules of the game are adhered to and obeyed by all the parties. And that's one of its primary tasks, to protect fundamental rights and to ensure that the democratic game is played on a level playing field in the correct way, and so on. So when you have a constitutional challenge that goes to the root of the very rules that structure or frame the democratic process, in this case, political party funding, then that should be a priority for the court to hear and to decide. The fact that that's now been pending for 3 years, while we have had multiple state elections, the national election, and actually looks like it's going to at least be pending for an entire 5-year election cycle of all the states and the center having an election, I think is speaks really directly to the institutional complicity that has allowed the scheme to continue as it has been so far. So with that, I'll close. Thank you.
Okay, am I audible? Okay, thank you, Gautam. I really like that phrase of judicial evasion. That's very appropriate. So I'll now move on to the next speaker and call upon Mr. Vihar Dhruve. He's a RTI activist and basically a chartered accountant and also a lawyer. And he works on various fields in the social domain. He works for justice to women and children and has filed a PIL in this regard. He's also filed a PIL for the infrastructure development of the courts in Maharashtra. He's worked for students who are wrongly failed by the Mumbai University, and he's working for zero tolerance to fire accidents in Maharashtra. In the case of electoral bonds, he has filed very many RTI applications and obtained very useful information, especially from the State Bank of India, which he had shared very widely. So with that as a backdrop, I'll request Mr. Vihar Dhruve to kindly speak. Thank you.
Good afternoon. I highly obliged to our ADR team for giving me an opportunity to share the information received by me under RTI. The finance minister, I will be explaining everything with the help of the PowerPoint presentation. So I'm coming to the slide number 2, the finance minister's speech in parliament. So can I have that slide, please? Hello, Major General.
Yeah. They will just put it. It takes a few seconds.
Yeah. Yeah, can you play that slide, please? The voice is.
Unless there's no audio, you can't hear.
No, yeah. Okay.
So we have no audio, but we have a ongoing video of the Lok Sabha TV or DD News going on. Can we stop that somehow?
Hello. You're playing that audio is not finance minister speech. Hello.
Mr. Dhruv, Mr. Dhruv,
Yeah,
can we please proceed without the audio?
Okay, the
This
audio
is-
is not. Yeah.
Yeah, audio was
Thank
not. We could not hear you. So I'm coming to what finance minister said. He said that we are bringing this electoral bond with an intent to bring the transparency in political funding. Now the finance minister has the rules, the features of the electoral bonds have already been discussed, and the main objection from the citizens' point of view, or from the shareholders' point of view, who are main stakeholders in the company, they should know how much money has been given by their company to the political funding, and most importantly, is there quid pro quo, means I'm not casting any questions on this farmers agitation, but the we as the citizens want to know how much donations have been given to the political party by this who would be entering in the farm sector or something like that. So slide number 3, we have discussed the rules and regulations and all that. Now electoral bonds notification we have in 2018 they have discussed. The most important thing is the RTI says that whatever information they have means any public authority has to publish it on their website. So I have filed many RTI in the Election Commission office, in the office of the Reserve Bank India, then the State Bank of India, then the Prime Minister's office, then the Finance Minister's office, then the Law and Justice Department. You see, the Election Commission in 2018, in 26 May 2017, you can come back to a slide number 4. Election Commission objections. Yeah, Election Commission objections. Basically, they have written in 26 May 2017 to the Legislative Department that you have amended the Representation of the People's Act, Income Tax Act, Companies Act, and this will bring this will increase the corruption in India. And this information is very important from the citizens' point of view and from the all the political parties. Basically, Election Commission is the nodal agency to monitor the elections in India. And this letter, which 26 May 2017, is very important. And this information was not on the Election Commission website. And Election Commission had requested me to pay ₹6 for these 3 pages of document, and they have spent about 50 rupees on the postage and all that. So the Election Commission told should have been more proactive in this, but unfortunately they are not. Now the Finance Minister, somebody in Parliament, I asked the Finance Minister whether the Election Commission has. I'm coming to slide number 5 now. Please come back to slide number 5. Yeah, Finance Minister misled the Parliament about the electoral bond. Somebody in the Parliament asked the question whether the Election Commission have received any communication from the Election Commission, and in writing the minister said we have not received any communication from the Election Commission. You see, I am having a document. I can see this has been already been disclosed and widely published on the media. At 26 May 2017, the Election Commission had written the letter to the law department saying please do not come with this thing. Now the basic question is, till date nobody has asked the Finance Minister to introduce the electoral bonds. The question on the purpose of electoral bonds introducing it, somebody says why is it there is a blackmailing, there is some threatening or something by the rival parties. If they come to know that the XYZ company has paid to a company so much money, so there is a black money. So the intention of electoral bond, introducing the electoral bonds as per the Finance Department, says that this will stop the corruption. But the RTI says, I'm on slide number 6. Yeah, the question of purpose of introducing the electoral bonds. The Election Commission, which is the nodal agency to monitor the elections in India, has given a very specific reply that till date, that is 2014 to 2018, there has been no complaint whatsoever from any corporate body or from any individual or from any political party regarding the blackmailing and something like that. So the very purpose of introducing the electoral bonds is a fraud, and this is very dangerous for the democracy. Now I'm coming to the slide number slide number 6. Can I have 7? The main important thing that there is a threat to the statutory auditors, and you see the chartered accountants sign the balance sheet of the political party as well as the companies, and they sign saying that we have audited the balance sheet of XYZ company for so and so period, and the balance sheet showed a true and fair view. In other words, the donors, and in the absence of the donors and donees, how any chartered accountant can sign the balance sheet? You see, the third party external evidence as per the chartered accountants auditing standards, which are globally accepted. They must know who are the donors and donees. You see, the chartered accountant, it is the primary duty of the chartered accountant who is signing the balance sheet to get the third party evidence whether XYZ amount has been given to X by a company or something like that. So in the absence of the donors and the donees, even to the chartered account, to the election commission, to the RBI, to the SBI, the balance sheet do not show a true and fair view. And these electoral bonds are a clear-cut recipe for the scam which has happened few years back, like a Satyam. It has brought very disrepute to the country as a such. And I appeal to the CA Institute to come out with the guidance note, because we do not want this kind of something fishy happening in the corporate world. And I also request the shareholders and the other parties to request their directors to publish everything in detail to the in their balance sheet. Now I'm coming to the slide number 8 now. Yeah, please come back to slide number 8, please. Slide number 8. Yeah. Now this is Mr. Vinod Rai. In 2012, signed an agreement with the United Nations, and that India is committed to a transparency and accountability and all that. So this letter shows that we are committed to a transparency, accountability, and everything in the accounts will be transparent. Every stakeholder will be committed. So electoral bonds basically violates this condition, not only in India but with the United Nations also. So now I am coming back to slide number 9. You see, electoral bond about they say that the ordinary citizens can also make a donation, but till date 2018 to 2020, maximum amount of electoral bonds were issued of 1 crore rupees, and there are roughly, whatever information I am having from the State Bank of India, is 5,981. 10 lakhs 4,943, 1 lakh 1,731, 10,070 rupees, and 1,000 only 48 rupees. So the Aam Aadmi has given a donation of only 48,000 out of this 3,000 crores. So therefore, this is a very dangerous for the country as a such. And now I am coming back to the whole of Central Information Commission, which I am very, very sorry to say that I filed the RTI application in the Reserve Bank of India. So the details of the correspondence which they have not given me. The RBI had taken the objection, and the objections letter was not given to me. Only they forwarded my RTI to the State Bank of India, and when I asked them, 2 RTI were filed in the, I am talking about this election commission's order. The 2 RTI were filed seeking the information about the amount of the donors and donees, and how many donation amount in rupees received by all the 7 political parties. So the Central Information Commission, despite having a public interest, they said that there is no public interest. So this violates the completely 2013 Election Commission's order. And you see, this amendment brought by the government clearly hampers the functioning of the Central Information Commission. There are n number of judgments. So there are Supreme Court's n number of judgments. For example, State of Uttar Pradesh and versus Raj Narayan, Bennett and Coleman, in the Mr. Shailesh Gandhi, founder of the RTI, and Central Information Commission had direct n number of times to the Reserve Bank of India to publish the details on the website, but despite of that, they are not published. Then there are the Lily Thomas versus Union of India, then Raj Gopal versus Union, then there is one PUCL, SP Gupta, and all this Supreme Court of India have directed the government to publish the information. So the finally, what the takeaway from me is that I humbly request on the behalf of the citizens of India to the Supreme Court that this matter should be taken at the earliest, and all the information should be in the public domain. That is donor's name, donor's name, how much amount they have given, and this is basically this bill has been introduced as a money bill, which is a fundamentally wrong. So in totality, this should be crashed. That is the one point. The second point which I want to say is that the CA Institute has to play a very important role in order to say that the stamp like a Satyam should not happen like this. And finally, I want to say the farmers agitation. Everybody is saying that the XYZ company is coming into the farm sector. XYZ is coming to the not coming, and something like that. So in the interest of a country, I humbly request that this agitation would not have taken place had the donors and donors name would have been published. So the Central Information Commission has really not done, not acted in the interest of public service. And this is what I want to say, that let the sunlight is the best disinfectant, and I want all the information should be put in your public domain. Highly obliged. Thank you.
Okay, thank you, Mr. Vihar. You displayed the role and power of the RTI along with the other RTI activists like Mr. Lokesh Patra and others in exposing a lot of facts and figures and putting them in the public domain, for which we are really grateful to you. Now I'll request Professor Jagdeep Chhokar to speak. You're all aware that he is a founder trustee of media and has been associated with this case in great depth. Over to Professor Chhokar.
Thank you, Verma. It has indeed been a privilege to listen to Nitin, Gautam, and Vihar, because these gentlemen have played stellar roles in this saga of electoral bonds. When I look at it as a collective institutional failure, I think it is actually a very kind of I can't think of another word except to say failure of our institutions. Now, if we go back to the electoral reforms from day one, which was February 2017, when the late Mr. Arun Jaitley made the budget speech in the parliament, and he had 2 paragraphs. The title of the 2 paragraphs was Transparency in Electoral Funding. Now, my good friend Dr. Qureshi never tires of saying that when I heard the first sentence of his speech, that we have not been able to do anything about electoral funding for 70 years, and now we are going to do something. So Dr. Qureshi keeps saying, I felt very enthused. But that apart, that speech, and then he held a media interaction in the afternoon of the 1st of February, in which he said this, what I would say dead giveaway sentence, that electoral bonds will be in the nature of bearer bonds. The identity of the donor will be anonymous. Now, the moment I read the sentence in the newspaper the next day, I felt that there was something wrong. And I have repeatedly written that I am looking for a dictionary which says that transparency and what is that called? Anonymity. That transparency and anonymity are synonymous or synonyms of each other. But I have not found that so far, and I have written it maybe more than 10 times in in the media, but there has not been any clarification. But that apart, the electoral bond scheme is unconstitutional from the point go. Its inclusion in a money bill is not constitutional. And we have raised this issue in our petition, although the Supreme Court, of course, has other important things to deal with, and they are not sort of bothered to deal with this at all. So, first, it is unconstitutional from the time of birth. So it is illegitimate, if I may say so. Then, as Mr. Nitin Sethi and his colleagues very, very clearly brought out, I mean, here are two institutions, the Election Commission and the Reserve Bank of India, which actually were not complicit to begin with. They expressed their concerns, their doubts, and I can't help but recall the comments of the then Finance Secretary on the file that Nitin had brought out. I mean, it is just amazing how things are overruled, overshot, and completely ignored, and false statements are made. So the introduction of electoral bonds over and above the objections of the Election Commission and the RBI, and as a part of a money bill, are the first sins that were committed, I would say. Then when the details came around, I mean, this was fascinating that a company could now donate 100% of its profits. The limit of 75% or 7.5% had gone, and the companies did not need to disclose the name of the political party or the amount. I mean, multiple such things happened, and I don't want to go into detail because we are kind of short of time. But the fact is that every single action under the Electoral Bond Scheme has worked to reduce or eliminate transparency or whatever the shred of transparency that electoral funding had. And then one of the things that has not come up, it was sort of a big thing that these are anonymous, nobody knows. Then our friend Poonam Agrawal decided to buy an electoral bond worth 1,000 rupees. And for whatever reason, she put it under an ultraviolet light. And lo and behold, there was a unique identification number. So I am using these instances to indicate that there is a series of falsehoods which have been propagated to try and show that this is a very great thing, which it is not. Then very soon when the rules came out, as has been mentioned earlier, that the political party in power has a differential advantage. I think Gautam used a different legal word for it. Now, I have a very simple explanation for this. Now, let us say Nitin goes to the State Bank of India Parliament branch and buys electoral bonds worth 10 crores. Now, this is purely hypothetical because I don't think Nitin has 10 crores. But still, let us assume. He buys the 10 crore electoral bond and gets into his vehicle and heads towards Akbar Road. Now, those who live in Delhi should understand that Akbar Road is the headquarters of the Congress party. So, at the next roundabout or the traffic circle, Nitin phone call. And somebody will say, "Oh, Nitin bhai, kem chho?" This, that, and the other. And he would say, "Arey, suna aapne electoral bond kharida?" So, if I were in Nitin's place, number one, I would start sweating. And number two, I will turn my vehicle toward the Chhokar road. So the point is that this was written soon after the introduction in 2017 that electoral bonds have the potential to choke the funding to all opposition parties. And at that time, it was expressed as an apprehension. Lo and behold, in the, I think, 2017-18 accounts of BJP, it was discovered that they had received something like 200 some crores of electoral bonds out of 220 or something, actually 95%. In the first tranche of electoral bonds, 95% went to BJP. Obviously, I mean, so therefore, it is not that it has the potential to choke or it will change the electoral landscape in the country. It has already done that. Today, the financial playing field, it is not only not level, it does not exist. There is just one player on the field. And notwithstanding the farmers' agitation which Mr. Durvik commented on, the farmers have been quite upfront as to where will the money go, and therefore we can assume where is the money coming from. So this, another form of crony capitalism, one may say so, is not only damaging to democracy, it has damaged democracy. I am not sure India can today call itself justifiably a democratic country. And that is obviously extremely sad for anybody who thinks the way we think. And of course, Gautam has gone into great detail about the Supreme Court hearing. I was present in all those 3 days, and it was amazing to see how the Attorney General of India said in the Supreme Court that why do citizens want to know where do political parties get their money from? Citizens should be interested in where do candidates get their money from. I mean, they should not worry about political parties. And the bench actually was surprised and they said, what are you saying? But the Honorable Attorney General stuck to his point. So the kind of mindset that prevails, and I don't need to go into what Gautam already said, the way this interim order was given, and subsequently we have filed urgent hearing applications a couple of times, because at the time of Bihar elections, we also said that, here again, a lot of money will change hands and nobody would be any wiser. But the Supreme Court did not see any reason to hear it early. So I am, maybe I'll be held up for this. I think the government is implicit. The Supreme Court is implicit. I don't think, for once the Election Commission and the RBI kind of have acquitted themselves reasonably honorably. So this is perhaps the biggest threat to democracy, or one of the biggest threats to democracy today. I don't know how to take it forward, because we are in the Supreme Court and we keep filing applications for urgent hearing, nothing happens. So I don't know how to take it forward, but this is something which was known from day one. And I would close with a comment on the other political parties. Now the Congress party claims that, we wrote a letter and we did this, that and the other. But no political party seriously opposed it. For the simple reason that they thought, kabhi hamara bhi number aayega. That when we come into power, we will be able to use the same tool. Of course, I must put it on record that the CPIM has actually filed a petition in the Supreme Court much after we did, and that hearing sort of they are heard together. But political parties, and when it comes to finances, I mean, what can I say? Every single political party is, well, I am nobody to say they're guilty of, but they are absolutely clear that they will not reveal their finances come what may. And this includes every single party. In the sample that we did for application of RTI to political parties, we had 6 parties: Congress, BJP, NCP, BSP, CPI, and CPM. So the whole range from the extreme left to the extreme right is covered. And nobody is interested in this. So unless our political parties are made to realize that they are accountable to the people or to the leadership, and they need to be, this is totally out of this purview of this, they need to be democratic in their internal functioning. Till then, I don't think anything will change. And in terms of political parties being accountable to their own members, you know, when this political party RTI being applicable to political parties order came from the CIC, in a seminar, I had a senior politician sitting next to me. I don't want to name that person, but this person said to me during a kind of a break, he said, "Chhokar साहब, आप जैसे लोग जो हमसे सवाल पूछेंगे उनके जवाब तो हम दे देंगे, हमारे मेंबर जो पूछेंगे उनके जवाब कैसे देंगे?" So political parties have a vested coterie which are kind of not even accountable to their own membership, and electoral bonds, and of course related issues, FCRA, which I will not talk about, are prime examples of complete disregard of the rule of law. And if rule of law goes, then democracy is already gone. Thank you.
Thank you, Professor Chhokar. Now, before we go on to the question answer session, which I think we are doing pretty well as far as time is concerned, we will give about 20 minutes for question answers. I would just like to again reiterate the topic which we have chosen: collective institutional complicity. I would request the speakers, Professor Chhokar has already given his mind, the other 3 speakers to give their views as to how do we move forward from here. We have seen that we are sort of at a logjam and nothing seems to be moving, neither the courts nor the political parties nor the institutions like the SBI. When we file RTI, even they have started giving vague replies now. Earlier they give information. And how do we really say, Nitin, what do you feel that as a journalist, what can be done? And I would ask Gautam as to how, if there is anything at all that we can do to push the cases in the court. And from Viharji, I would like to know what best can be done with the RTI, because knowing that day by day the RTI is also being diluted and things are not being answered. So first, Nitin, please. I think you're muted. Yeah.
Sorry, am I audible now?
Yeah, we can hear you now. Yeah.
I was saying it's generally not a good idea to ask a journalist to suggest what society should do, but at the risk of becoming a point of joke, I would say 2 or 3 things which are perhaps possible under the restraints that we are. One, instead of, when we have moved into a period where the government refuses to share information under RTA, I think to run a campaign of saying the RTIs that the government does not respond to? What are the questions that we keep asking different departments repeatedly, and put that out to explain to citizens that this is what the government does not even answer on something that it calls a very transparent scheme. I don't see that growing great guns, but it's at least continues the conversation and does not wait for the government to hopefully one day see light and say we should be answerable to our citizens. Two, as journalists, I think we will soon produce some more investigative work, which both looks at how electoral bonds have been utilized by political parties, and to suggest towards what kind of businesses and expenses the political parties putting this kind of money towards. I think for us as journalists, in a very restrained atmosphere where journalism in general has become difficult, we at the Reporters Collective believe there is still enough space to keep pestering, plugging at it. I would request others to join in. I'm sure there's so many other brilliant journalists who can, given the freedom by the editorial command, do so much more on this and other issues. We will in the next month, roughly about in the next month, produce more reportage on the electoral bonds and electoral funding linked issues ourselves. I do think that, as Gautam and you and Dr. Chhokar has talked about, actively raising and openly raising questions about the efficacy of the institutions, and not going by the dogma that these are old institutions that have done well for us, but to challenge them to actually live by the letter and the spirit of their mandates, which I think we've also failed. We thought, the fact that the RBI has written one letter is good enough, or they wrote 3 letters and it's good enough. The fact is, they could have prevented it. Similarly, the Election Commission could have taken 5 additional steps even after the scheme was implemented to make sure it doesn't go down the path it has. I think for us to task the institutions to the highest possible levels of governance and not compromise and say, well, under the circumstances, this is good enough. I think that's where we need to focus. I don't see my answers being very substantial in terms of providing guidance, but I hope it provides hints. Thank you.
Thank you, Nitin. Thank you very much. I think Mr. Gautam Bhatia has left. So I'll request Mr. Vihar Durve. What would you recommend? Where do we go from here? You are muted.
Hello, I would request all the shareholders to seek the information from the directors of the company about the political donations made by their companies as such. Then I would also request the farmers who are main stakeholders. They are saying to say, oh, yeah, XYZ is coming in the picture in the farm sector or something like that. So I want all the entire lakhs and lakhs of farmers to file the RTI in the State Bank of India or the respective in the public authorities, and seeking the information about the how much donation they have made, and what is the link between the donations, and how whether the farm laws have been bought only because of some XYZ party has contributed to XYZ party. Then there is also important features such as the RBI's role. RBI is not playing a very proactive role, and most important thing, in my opinion, that in 2013, I believe in your petition, that they have said that political parties are coming under RTI. And when I have sought the information about the donors and donate details and how much they have made to 7 political parties, the Central Information Commissioner said, no, citizens do not have any public interest in that, and my RTI application was dismissed. So the auditing of the orders of the Central Information Commission is very, very important. You see, even if I'm diverting a little bit from this topic, I have been denied the information by the election commissions about the how much money was spent to extradite Mr. Vijay Mallya by Nirav Modi, then Mehul Choksi and something like that. So in 2014, to 2019, the election 2020, the election the Central Information Commission is not playing, not abiding by the Constitution, not abiding by the RTI, and not abiding by their previous orders. So this is very, I want the citizens to play a very important role, especially during this farmers agitation. Farmers must come and make these companies accountable and our political parties accountable.
Okay. Thank you, Mr. Vyar. Okay. Nandini, now we can take the questions from the audience. Kindly display them on the ticketive. Okay. So, by Commodore Lokesh Batra, he's sitting in US, but I think he's watching in spite of the time differential. So, government not holding sale of electoral bonds in April and July 20 in violation of EB notification dated 2nd January 18. What legal pundits have to say?
I just want to say, Commodore Batra is watching everything all the time.
So maybe Professor Chhokar, you can respond to this. He's asked for legal pundit.
What can be done is, there is a very serious limitation here of law. Law is to be implemented through the judicial system. And unfortunately, the judicial system is not responsive. We are talking of electoral bonds. There are over 100 habeas corpus petitions pending from the Kashmir region over 2 years. So, of course, we can file something, but I am not sure that would lead to anything new. And government decides not to hold a sale, well, it is the government who decides. So I don't have anything to add, and I'm sure Commodore Batra knows all this. But that's about it. I'm not sure anything can be done here.
Okay. Thank you. Nandini, next question, please. Again from Commodore Batra, why is ECI silent and not sending reminders to the government on EC's apprehension about the EB scheme?
I think we should have invited Commodore Batra to be a panelist. This question only ECI can answer. How can we answer this?
Okay. Next question, please. Nandini. Okay. Lakshmi Narayan is a journalist. He has sent an email also, which I saw. So why is the government not switching over to state/national funding of parties and elections like France in place of the corporate funding to curb conflict of interest and corruption? Nitin, can you take this on?
Sure. So, state funding of the electoral processes is also has its challenges. But I think there have been several proposals on the floor of how this could be done better, utilizing public funds with transparency, limiting the space for corporates and other non-voting entities to stay out of the business of elections. But clearly, the risk that I'm just speaking as a journalist who tries to understand political economy, that in this case, there's a disadvantage for the first mover. Say if a party in opposition says, I will not get into electoral bond, it's a dirty game, I will want to go into something else which is cleaner. Then because the rest are still playing dirty, that party is at a disadvantage. So it does require political consensus amongst a substantial number of political heads and say, we will abjure this anti-democracy idea. We will move towards an idea of electoral funding more progressive, which strengthens democracy. But if the party in power itself continues to not only promote, but make sure this persists, the Supreme Court watches it blindly and the institutions like Election Commission sit on it quietly, I would even use the word scared to respond to the government's aggression on this scheme, then we are in a bad position. I do not see a quick resolution of this unless the Supreme Court really wakes up to do what it's required to do, and which is hear this petition in detail and respond to the constitutional challenges that's been raised about it. There is
Can I add
possibility. There is a schematic possibility of us thinking about in the future of a more progressive. But the two principles, and I'll stop with this, the two principles I keep thinking of electoral funding that we should keep in mind is one, transparency that we've talked about. Two is equity, which allows all kinds of new emerging political parties an equal opportunity to garner funds from citizens if they want to rise and become a larger party. Otherwise, political parties that represent interests of marginalized people, parties which are just emerging, they will face a great challenge compared to the existing players, if I may use the word, in the market. That's it.
Okay, thank you. Professor Chhokar wanted to say something.
No, I want to share the specific instances that, first of all, this state funding and national funding are not the correct terms. The correct term is public funding. For the simple reason that, for whatever reason in India, we have the sense that whatever the government is free and whatever is with the government is ours. I remember in an election, some candidate said that our leader has given us a slogan, "Jo zameen sarkari hai, wo zameen hamari hai." So if we refer to it as state funding, people at large don't really associate it with the money that is collected through the taxes that they pay. So number one, it should be called public funding. Number two, there have been repeated, reviews and commissions, and the most quoted report is what is called the Indrajit Gupta Committee report. Now that report also in the very first paragraph of its conclusions chapter says that state funding of elections can only be thought of after several other reforms such as internal democracy, etc., are put into place. Number two. Number three, one of the assumptions of state funding or public funding is that political parties and the candidates who contest elections will be given public money to contest elections because this is a public cause, which is perfectly all right. But then they have to then agree that they will not take money from anywhere else, which I am absolutely certain no political party is willing to agree to. And if they don't agree to this, then you can give them public money. They will still take money from wherever they can. So then it becomes a case of throwing good money after bad money. I mean, you can't tell a civil servant who's in the habit of taking a bribe that you will increase your salary 3 times, but you stop taking a bribe. You increase the salary, but the person will keep taking a bribe also. Then the last point is very, very practical. Then let us say we decide to provide public funding. Now we will have to sort of make a budget for it, make a provision for it. And I guess what the government does in most cases is they take the figure of last year and add some 10%, 15%, 25% and then budget. So therefore, what it means is that we need to know how much money was spent by all political parties and all candidates on their election so that we can make a corresponding provision for public funding. And I can assure you, Mr. Lakshmi Narayan, whoever asked this question, that to find out how much money was actually spent in the election is impossible. Since we don't know that, we can keep giving money. This is not going to work. Political parties have to understand and agree to be transparent about financing. Without that, there is no point in discussing anything further.
Thank you, Professor Chhokar. Nandini, we'll take 2-3 questions more. Okay. Question from Jenny Halim. Lack of public awareness or lack of political will? Which is the bigger obstacle while dealing with electoral board related concerns? Mr. Vihar, would you like to answer this?
No. Means they both are equally responsible, and I would like to humbly submit that the little bit diverting from this, the political party, their balance sheet do not reflect one fairly because the whatever expenditure, the expenditure what is being reflected in the balance sheet only relates to the cash and check expenditure. The whatever has been acquired by the on credit, they that entries are not being paid, and the public as well as the lack of political parties both are responsible, and at the time of the voting the citizens must know their duties, and that they if they vote to XYZ political party, they know already what is the result, so therefore they have to be constantly vigilant, and अदरवाइज वो देख लेंगे हम देख लेंगे उनका ये हमको क्या करेगा हमारे वोट से क्या होएगा दिस काइंड ऑफ रोल cannot be sustained in a democracy. Everybody must be aware and they must make accountable to the political party and they must participate in the democracy.
Okay, thank you. Next question, please. The question is from Sanjukta Basu. Are the electoral bonds the only source of political parties' income? What other sources should we scrutinize? Is the Election Commission allowed to audit accounts of the parties? Okay, I'll answer this. Firstly, electoral bonds are not the only source of political parties' income. They have a number of sources, right from coupons and hundi collection and subscription from the party members and collection from the public and of course from the corporates and all. They are required to disclose officially in their donation and contribution reports all donations above 20,000 rupees which they receive. So technically, all donations below 20,000 rupees are from unknown sources as far as we are concerned, because the public does not know where this money is coming from. And this varies from year to year. Generally, it is between 50 to 60% of the income of the political parties. It's from the unknown sources. With this electoral bond scheme where the donors are anonymous, we do not know who they are, that percentage of unknown sources has increased now. And the Election Commission allowed to audit. Okay, the rule is that the political parties themselves get their accounts audited by chartered accountants, which they have. Though, as per the Law Commission and various other committees and electoral reforms which have been recommended, it has been suggested that the chartered accountants should be from a panel which is approved by the Chartered Accountants Council or approved by the comptroller CAG, but that has not been implemented. But that suggestion is there. Okay, next please. Okay. The Electoral Bond Scheme has indeed challenged the superiority and autonomy of the Election Commission in electoral domain. How did EC react in the court? If you can put some light on that too. Thank you. Professor Chhokar, would you like to? You are muted, sir.
The Election Commission had actually, as was mentioned earlier in the discussion, had objected to the Electoral Bond Scheme when it was being formulated. And then Subsequently, also the Election Commission ended up writing a letter to the Finance Ministry listing out its objections. And that somehow came to be in the public domain. So therefore, Election Commission in the court gave an affidavit listing out all the problems that it foresaw with the electoral bonds, and it did not support the electoral bond scheme. So Election Commission opposed the electoral bond scheme in the court also.
Okay. Thank you, Professor Chhokar. Is there any other question? One more, we can take a last question if there is, otherwise we'll close. We've had enough questions from Commodore Batra, and this one was to be answered by Nitin. He is already left, so he can ask
No,
it.
we can only request Commodore Batra to join the next discussion as a panelist.
Okay. Right. So I think we will end here. I wish to thank all the speakers, the panelists, and the audience for their questions and their participation in this, which has been a very invigorating discussion today. And a certain number of ideas have been thrown up by the speakers as to what we need to do next. So we from ADR and we would request the other panelists also in their respective spheres to kindly take this forward, because this is a very important feature which we need to continue working on. Thank you very much. All the very best.